Hi, good afternoon. My name is Arshi Pal. I'm an attorney with Littman Krooks, and I represent students with disabilities and their families at Impartial Hearings. And we're really excited to have you here at our Lunch with Littman Krooks, and we hope you'll also be joining us next week. These are, nice informal sessions where you can ask us questions, and we can give you like briefs and tips on various legal concepts. So jumping right in. If you guys have any questions, I asked if you can wait toward the end when I'm done with my presentation. But feel free to write them as I'm speaking, so you don't lose your train of thought. But I'll check them a little bit later on. And so, getting right into it. The statute that we'll be focusing on and the federal law that we'll be focusing on today is the IDEA, which is the Individuals with Disabilities Education Act. And under the IDEA, school districts are required to provide a FAPE, what's called a free appropriate public education to students with disabilities. And the core of the statute, the whole idea is like a collaborative process between the school district and the parents. Everyone is thinking of the best interest of the child. And federal courts have seen that a school district provides a free appropriate public education when it offers special education and related services to meet the unique needs of the student. And those services must be reasonably calculated to enable the child to receive meaningful educational benefits. We had a recent Supreme Court case called Andrew F., which noted that the educational program that the school district provides the student, it must be appropriately ambitious in light of the student's circumstances. So they compared it to an individual or a student who might be in a general education classroom to see if that student is making progress. They must be advancing grade to grade, but for a student with a disability, they have unique needs and they have different benchmarks in a student than that might be in general education. So it's a bit of a fact-intensive inquiry based on the student's unique needs, and that's pretty much the background of how we get into an impartial hearing. So typically you'll see a student with a disability may have an IEP, what's called an individualized education program, which lays out pretty much their strengths, their weaknesses, their functioning level. Also, it lays out the various related services and education program that the school district is going to be offering that student. It talks about various concerns that the teachers may have, various concerns that the parents may have. And if the student is old enough, they may also attend this IEP meeting and they can talk about concerns and what they consider their strengths and weaknesses. Additionally, so the way we can get into an impartial hearing situation is we'll be focusing on the parent's perspective. And it's when a parent feels that their child has been denied a free appropriate public education. So an example of this may be when we have an IEP meeting and there's a classification on an IEP, which talks about what the student's disability is. So there are various classifications such as autism, intellectual disability, speech language impairment, OHI, other health impairment, along with other ones. So the classification is very important for an IEP because it lets the students, related service providers, their teachers, individuals in the school building who have access to the IEP kind of, look at the IEP and realize what is the child's primary disability. And there are instances where the school district and the parent may have a differing opinion as to what the classification should be. And sometimes we note that students with autism have specific safeguards under the commissioner's regulations. So typically it could be one of the reasons for disagreement between a school district and a parent. And then additionally, other disagreements that may lead to an impartial hearing may be the student's placement, additionally along with their program. So on an IEP, there are various programs that can be offered to students with disabilities, such as a classroom with a 6-to-1-to-1, 8-to-1-to-1, 12-to-1-to-1, 5-to-1, 15-to-1, or what's called the ICT class, where there's where it's general education students with students with disabilities, and there's two teachers. One would be a special education teacher and one would be a general education teacher. So sometimes school districts will recommend an ICT classroom for a student with a disability, but the parent may believe that that child needs a smaller classroom setting, such as a 12-to-1-to-1, which means 12 students, 1 teacher, and 1 paraprofessional. And in such a scenario, that may be a reason for a parent to file what's called a due process complaint or a request for an impartial hearing. And that in essence triggers this whole impartial hearing process. But as we mentioned, I will be saying, some good tips and techniques to kind of preserve your record, because this impartial hearing will be in essence recorded. There will be what's called a transcript, excuse me. And then if you as a parent will also be providing evidence. So there's testimonial evidence where you can have witnesses. There's also documentary evidence. So let's say we're in a situation where you just got out of an IEP meeting, or you just received the finalized IEP, and there are various instances in the IEP that there are things that you don't agree with. A good practice tip or a good technique may be to actually write a letter. You want to have writing rather than calling, because later on, if you do end up in a situation in an impartial hearing, you're preserving your record. You're showing that you tried to work with the school district. So you're writing, please be respectful and courteous, because emails, text messages, anything like that can be part of your evidence. Let them know that, listen, we had this evaluation, and this evaluation is recommending that my child be put in a 12-to-1-to-1 classroom. I request that you reconsider this ICT placement or this ICT classroom. There's other instances where there can be a disagreement with regard to evaluations. That may also cause a party to seek an impartial hearing. But usually when a school district conducts evaluations and the parent disagrees with the school district's evaluations, the parent has the right to request an independent evaluation. And at that instance, the school district will have a choice. They can, provide the independent authorization for the evaluation, or the school district can have an impartial hearing to defend why their evaluation is appropriate and why the parent should not receive an independent evaluation. And other procedural violations that may cause a parent or a family to file an impartial hearing may be things such as they weren't told about the IEP meeting. The IEP team went ahead and held the IEP meeting without the parent, and the parent had no way to put their input, disagree, add, important information that the parent may have with regard to the student's likes, dislikes, strengths, weaknesses, behaviors, certain triggers that the parent may have this personal knowledge of. It can be very helpful for the school district to understand the student's unique needs. And then additionally, what we want to be mindful of is that there is in New York State a 2-year statute of limitations. So when you are filing this impartial hearing, it's from the date of your impartial hearing, 2 years prior to that. So let's say that you had an IEP meeting in 2016. Well, now it's 2020. Then you're a little late to talk about procedural and substantive violations for that IEP meeting. But if you had one that was in 2018, September 2018, you're right in that 2-year period. So it's better if you believe that there has been a denial of FAPE for your student, for your child, then you're better off filing for your due process complaint. And getting to that complaint, you have to be mindful that you want to specify what exactly is the nature of the dispute. You don't want to go, there's a balance to strike with regard to providing the educational background of the student, but there's also, you also want to be mindful to provide exactly what happened. What is the issue? What do you want the impartial hearing officer, who will be the administrative law judge adjudicating this case, what do you want them to know, and what do you want them to, you know, provide as your potential relief? You want to be as clear as possible. And you want to be careful, because any claims that you don't present in your due process complaint can be potentially thrown out. So for example, if you have a student who is supposed to be receiving occupational therapy on their IEP, and you're filing a due process complaint talking about the fact that they were provided on their IEP an inappropriate classification, you also want to talk about the fact that if they didn't get their occupational therapy mandate, because you may be later on barred from bringing that up if you don't sufficiently plead it in your complaint. Additionally, you also have, when there is a dispute between an IEP regarding an IEP placement, there is what's called a pendency. So pendency means when you can the last agreed upon IEP is to be followed until the decision is rendered for this current proceeding. And then after we file the due process complaint, we want to be mindful that when we are filing the due process complaint, that it doesn't come back for insufficient information. So things that are very important is make sure you name the student who is the subject of the impartial hearing. Make sure you have their date of birth. Make sure you have their New York City ID number. Make sure you have what school they're currently attending. Make sure you have your information. How are you related to the individual? Are you their parent? Are you their legal guardian? What is your interest in this? Do you have standing to bring this impartial hearing? After the impartial hearing is filed, then within 14 days, the school district has to hold what's called a resolution meeting, where they try to either address or you know, settle certain things in the due process complaint, such as, for example, what we've seen in the past is if we ask for evaluations in our due process complaint, usually the school district, if they think it's warranted, will try to get those done during the resolution period. So it would be one less thing that the impartial hearing officer has to address in his or her decision. Additionally, if for some reason the school district and the parents, they both can waive what's called a resolution period, that, you know, it's seen that there's definitely no way that any of the issues raised can be addressed or dealt with in the resolution period, they can waive the resolution meeting and proceed to hearing. They can notify the impartial hearing officer of that, and then within 14 days of that, you know, finding out that there's either been no resolution or partial resolution, the impartial hearing officer can hold what's called a pre-hearing conference. And at that time, that would be usually when the impartial hearing officer will talk about, let's clarify, what's the relief requested? What are some of the things that you're asking for? So some of the things you can seek in an impartial hearing office, in an impartial hearing is, you know, funding for a private school. You can seek independent evaluations. You can seek compensatory related services, compensatory education services. So for example, what that means is to make up for the fact that the student was denied a FAPE for a period of time, 2 years, they should be entitled to receive services to help them make up for that denial of FAPE, to help them make progress in essence. And so pretty much when we're at a pre-hearing conference, the impartial hearing officer will ask, what is the relief that you're seeking? Are you seeking to place the student in a NPS, which is a non-public school? So that's a private school. Do you want to put the student in a private school? Do you want the student to receive compensatory occupational therapy? Do you want them to receive compensatory physical therapy? Do you want them to receive compensatory tutoring? Various things like that. But remember, we have to put this relief requested in our due process complaint. And also at that pre-hearing conference, the impartial hearing officer will also, confirm whether or not there were any resolution agreements that addressed any of these reliefs that the parent may be seeking. And then the impartial hearing officer may also talk about, well, who are your witnesses for this hearing? The Department of Education in New York State has the burden to prove that they provided a free, appropriate public education to the students. So, for example, that may show, what they may want to show is that the student has made progress. So they might show progress reports, they may show report cards, they may show IEPs, they may show the evaluations that they conducted. They have to meet that standard, and then it's on the parent to show that the relief that the parent is requesting is appropriate according to the denial of faith. If we don't have a school district that's not, if we have a school district that's not putting on a case, they're in essence saying that, listen, we did fail to provide a free, appropriate public education to this particular child. And then the burden falls on the parent to show that if they're asking for, let's say, 100 hours of compensatory occupational therapy, it's appropriate based on the district's denial. So maybe we can show that the student has regressed based on the failure of the district to provide the occupational therapy, or we can show that the school, there's various ways to show that the occupational therapy might be appropriate, is that maybe the student was mandated to have 2 hours of occupational therapy per week. We can see how many sessions that he missed and how many hours that equals. So getting back to the pre-hearing conference, the impartial hearing officer will ask who's going to be your witnesses. So let's use that same example of occupational therapy. Maybe as a parent, as a school district, if they are putting on a case, they'll put on their occupational therapist from the school who works with that child. Maybe they'll also put on the teacher who works with the child to show that, based on the school district's observation, they believe the student was making progress with regard to his fine motor skills, with regard to his handwriting, with regard to his grasping scissors, along with other writing utensils. However, as a parent, our witnesses might be like an outside therapist that the student works with, or maybe we can even get an outside evaluation from an occupational therapist to show that the student is, really behind, or he's regressed from what he was maybe a year ago when he was receiving the sufficient services. Or maybe the school district failed to provide occupational therapy at all. They didn't even recognize this need for the student. So maybe we can talk about that. We can have a witness who is familiar with the student, who's evaluated the student, who recommended, maybe even a doctor who's recommended and noted this need for the student, and at the school district never provided it. So at the pre-hearing conference, we'll talk about who our witnesses will be. We'll talk about hearing dates, like what is a good time for both the school district to have their witnesses available, what's a good time for the parent to come and have their witnesses available as well, and what would be like a sufficient time to prepare what's called a disclosure. So in partial hearing, you will have the two parties presenting their documents to support their case. And those disclosure documents are due 5 business days prior to the date of the impartial hearing. So you want to be very careful, especially if there's any federal holidays, school holidays, that you don't end up missing your disclosure deadline, because at that time, it will be in the discretion of the hearing officer along with the other party to allow your evidence or not. Additionally, at that time, you will have to then confirm your witness list with the other party. So let's say, I have an impartial hearing coming up next week. on Wednesday. Today would be our disclosure deadline. And I would have to submit my evidence to the school district. I would have to also advise them of who my witnesses would be. And in certain hearing officers allow, this is upon the discretion of the impartial hearing officer, they may allow you to give what's called a affidavit in lieu of direct testimony. So you actually have written out everything that you want your witness, everything your witness is going to be saying. It has to be, you know, under oath, and it'll be signed and notarized. Some impartial hearing officers actually want direct testimony live, where the you know, the party is questioning their witness, and the witness is answering in front of the impartial hearing officer. But if you are allowed to do, and if you want to do an affidavit in lieu of direct testimony, you have to have your witness available so the other side can cross-examine them. So that might be something to consider in terms of timing. And another thing that you may want to consider is impartial hearings don't necessarily only happen in one day. It really depends on the schedule of the impartial hearing officer and all of the parties involved. So we may have, like, for example, an hour tomorrow where we're having an impartial hearing. We only have availability for one witness. So then we may come back maybe in the day after or the week after, depending on everyone's availability to do our next witness, and so on and so forth. But we do want to be mindful that the impartial hearing officers do have what's called a compliance date. So under the regulations of the special education, impartial hearing officers have 45 days to render their decision. So sometimes impartial hearings, if we have had situations where we've worked in a resolution with a school district where they said that they're going to have evaluations, they're authorizing evaluations for the student, and and we feel that those evaluations will actually help to show the impartial hearing officer what the student's strengths and weaknesses are, what can help the student moving forward. So, and we have to be careful. We can ask the impartial hearing officer for what's called an extension of the compliance date, but we have to demonstrate that it will not harm the student. Some students are in a crisis mode where, you know, they can't wait more than 45 days to have a decision from an impartial hearing officer. And that's the impartial hearing officer has to weigh the pros and cons of allowing that extension. If the extension is granted, then, you know, we can have another pre-hearing conference, a status conference, an actual impartial hearing, and then we can review what the status of the case is. And then at that time, you may also want to do another extension. But you want to be very mindful that you don't want to keep asking for these extensions while it's causing a delay, unduly delay, when there's a faster way to get, like, for example, there's a faster way to get the evaluations, or there's something that, you know, you can speak to a district representative to get an IEP meeting done. Whatever it is, you want to try to move along faster, because currently, especially right now in New York City, we're facing a extreme backlog. So we have cases that we filed back in February and March, and now it's already the end of August and we don't have impartial hearing officers assigned. So we haven't even had a chance to get heard yet. And sometimes it's usually because the impartial hearing officers' calendars are so overbooked because they have so many cases. So if we keep asking for an extension, we're still on their roster, but we're kind of clogging the system. So it's always a good idea to try to collaborate with the district to see if there's anything that you can kind of, you know, address prior to, excuse me, prior to having an impartial hearing officer assigned, or prior to even having the pre-hearing conference. So that will move things right along. I'm sorry, I'm just looking over some of the questions that we're getting in. So Somebody asked a question, can you file for an impartial hearing to cover grievances for over prior 2 years? Technically, no. However, there is a caveat. If there's a finding that the school district stopped you by providing misrepresentations from filing. So let's say, so the statute of limitations is you must file within 2 years of when you knew or should have known of the denial of faith or the alleged denial of faith. However, if the school district stopped you or prohibited you from filing your due process complaint in time because they were misrepresenting to you, either the placement or the progress or something like that, that's the caveat and the exception to when you can go beyond that 2 years of the denial of faith. And then there's a question of pendency when it applies. So typically, and the question specifically mentions CPSE to CSE, which is the Committee on Preschool Special Education and the Committee on Special Education. So when a student is less than 5 years old, they're in the Committee of Preschool, they're under the Committee of Preschool Special Education, and when the student is 5 years old or older, they're in the Committee of Special Education. Those are the people who are in charge of creating the IEP. Usually, we've seen a lot of pushback from pendency from a CPSE to a CSE, which is, usually in preschool, students are in a little bit more of a supportive environment. Sometimes they're in private institutions in CPSE. However, if you can get your district representative or if you're able to speak with someone at the district, they may do pendency. But that would be more so when there's like a agreement between the parties. Usually impartial hearing officers don't like to grant pendency from CPSE to CSE. And then, so getting back to the impartial hearing. So let's say today is actually an impartial hearing. What usually occurs? So when you're at the impartial hearing, and you may have a representative, or you may go what's called pro se, that you're representing yourself. And at that time, the impartial hearing officer will ask you to make your appearance. So you'll say on the record what your name is and what your affiliation is to the student. Additionally, the district representative will also make their appearance. And then at that point, the impartial hearing officer will ask to see your evidence. So that's the disclosure that I was mentioning, and that must be submitted 5 business days prior to the impartial hearing. And things that you may want to include as a parent to prove your case is the IEP, any progress reports, any report cards showing that the student is not making progress, any behavioral anecdotes, any behavioral logs, any correspondence or emails between the school district and yourself, any text messages. That's why I was mentioning earlier to try to be courteous and respectful, because anything that you have in writing can later on become evidence. Additionally, you may want to have private evaluation. Sometimes we have doctor's notes, that show what the student needs. We have, if we're doing what's called a tuition reimbursement case, you want to show the contract between the parent and the private placement. You want to show that. So as a parent, what you want to show is that the school district was on notice that the student was not making progress, and you tried to work with the school district. Like I mentioned before, collaboration between the school district and the parent is very important under the IDEA. You want to show that you tried to cooperate. So some instances where we've seen that hearing officers found that parents did not cooperate with the school districts, they either took away some of the relief requested or they dismissed their case. So for example, we had a case where a school district asked for what's called a consent for evaluations, and the parent denied it. She said that I'm not giving consent for you to evaluate my child. And then when we went to hearing, the impartial hearing officer said, well, you know, I'm seeing this as the parent's refusal to cooperate. However, we rebutted that presumption by showing that the student was so severely anxious that he could not undergo the evaluations that the school district was planning to do for this child. And additionally, the parent had, you know, prior evaluations that were relevant, and they were, you know, within a year of that student being evaluated. So we rebut the resumption. However, those are some hurdles that you want to be mindful of, that you don't want to make it seem that you weren't cooperating with the school district. Additionally, you will, after presenting your evidence to the impartial hearing officer, you can make what's called an opening statement, where you summarize the case, right? You want to remind the impartial hearing officer of what you said in the complaint. You want to explain who the student is, how old he or she is, what their classification is, what is the nature of the dispute, and what you believe, who your witnesses are and what they're going to say, and what you believe will adequately help the student make progress. So what is your relief requested? What are you asking for? And then the school district may also make their opening statement. Similarly, they will talk about how they believe that they provided a free, appropriate public education to the student. They will talk about who their witnesses are and why the parent's relief requested should be denied, because that's their case. Then at that point, the school district, because it's their burden to prove that they provided a free, appropriate public education, will present their witnesses. So at that time, when they're questioning their witnesses, after they're done questioning their witnesses, you as the parent will have the opportunity to cross-examine the witnesses based on what they testified about. So for example, if one of the witnesses says, well, I was at the IEP meeting on January 21st, 2020, and you as a parent were at the meeting, and you know that they weren't at the meeting, you can go up and say, are you sure you were at that meeting? Let's look at the IEP. Is your name on that signature page? You want to be very mindful of what you're saying at that impartial hearing. You know, I cannot emphasize that we have to be courteous, because everything being said at that time is being recorded. There will be, at the end of the impartial hearing, there will be a transcript where what everyone said is written down. And that's to help the impartial hearing officer later on when they're making their decision. They can review what each witness said. But all the witnesses will be sworn, and anything that they're going to say is going to be under oath. So you do not want to make false representations as a witness or as a parent in an impartial hearing. Additionally, if you feel that you know, one of the witnesses on the other side is making false representations, see if you have any documentations in the record, either your side or the district's documents, and say, well, let's open up this document. You just said on direct testimony that, you know, you were at that hearing, you were at that IEP meeting. Well, we don't see your name on the signature page. Are you sure you were there? Things like that. And then after the school district presents their witnesses and you had your chance to cross-examine them, it's your turn as a parent to have your case presented. So you will have your witnesses. You can ask, what you can do is you will prepare your questions ahead of time on certain key elements that you want to bring out from your witnesses. So for example, if we have a doctor, we want to have our list of questions prepared prior to the hearing. So we want to ask, well, who are you? You know, what's your name? Say your name for the record. What are your credentials? Do you hold a license? Do you hold you know, a master's degree? What are your degrees? What are your certifications, licenses? What is your experience like? Have you been working as a doctor for 10 years? Have you been working for a doctor, you know, did you start last year? And what kind of population do you, we are building up your doctor's credibility in the eyes of the impartial hearing officer. Then we want to make sure that we ask the witness how they're affiliated with the student. Have they been working with the student, you know, less than a year, 5 years, 10 years? And when was the last time they met the student? How many evaluations or observations? Various things like that to kind of show why your witness is credible. then we want to point out exactly what's their relevance to this case. Well, or did you make any, you want to ask your witness, did you make any recommendations regarding this student? What were they, and what were your recommendations based on? Do you know whether or not those recommendations were followed? If they weren't followed, what are some of the consequences of them not being followed? Have you noticed any regression in the student? Various things like that you can ask your witnesses. And, you know, as I said, be mindful that they are under oath and they must answer truthfully. And after you are done asking your witnesses the questions, after, you know, that's what's called direct testimony, then the district will have a chance to cross-examine your witnesses. So they can say, well, you know, you just mentioned X, Y, and Z. However, similar to your cross-examination of the school district's witnesses, they can cross-examine your witnesses. But then you also have a chance to redirect. So if there's something that you need to clarify that came out in cross-examination, you have the opportunity to ask the witnesses those questions. And then at that point, the school district will have the opportunity to call what's called rebuttal witnesses. And those can be individuals who will try to either rebut anything that one of your witnesses said or something that you said. And after the rebuttal witnesses are called, the impartial hearing officer will allow the parties to make closing statements. So again, you're summarizing your case, and you're also showing why the relief you're requesting is appropriate. Sometimes impartial hearing officers will allow what's called post-hearing briefs. So that would be, instead of having your closing statement on the record live while you're at the hearing, you can actually present it after the hearing. And then after you submit your closing brief, or after you say your closing statement, and then the impartial hearing officer will render their decision. And then if you have a favorable decision, you will work with the implementation, you will work with the school district to implement that decision. And then if you have, unfortunately, an unfavorable decision, you have the opportunity to appeal it to a SRO, the state review officer, within 35 days of that decision. But pretty much, you want to be mindful that if you're at an impartial hearing and the compliance date is either that specific date of the hearing, or you know, a week later, but you want maybe 2 weeks to complete your post-hearing brief, you want to make that request for an request for an extension of a compliance date, and you want to remind the court or remind the impartial hearing officer that it will not harm the student. And then other things to be mindful of is try to have conversations with the students, providers, teachers. You know, you want to try to avoid, if possible, having to come to this impartial hearing, because sometimes we've seen when you have an impartial hearing, it causes a little bit of a rift in the relationship. The teachers may be thinking that they're doing what's in the best interest of the child, you know, but if you don't express what you know you're seeing at home, or if you're seeing the student is struggling, maybe the teacher is not seeing the same thing. So you may want to email them, you may want to text them, send a letter in the bag. If you ever send a letter in the bag, keep a copy for yourself, because as we mentioned, you know, it could be used in this impartial hearing as your documentary evidence. But try to have that open dialogue if at all possible, because sometimes you can avoid even having to come to an impartial hearing. And you know, these impartial hearings can take anywhere from 2 months, 6 months, to 8 months to a year. And at that time, the poor student is, you know, in essence, still struggling. So that's something to be very mindful of. Let me take a look if we have any other questions. Feel free to post questions if you have any. So somebody mentioned going quickly over the safeguards specific to ASD classification. So, you know, I can't read all of them, but Most of the some of the safeguards include the specialized classrooms for students with ASD, so 6 to 1-to-1, 8 to 1-to-1, additionally 12 to 1-to-1. There are other programs such as the NEST program or the ASD program for students with autism. Additionally, there's also what's called parent training and counseling that should be offered in an IEP to parents who have students with autism. And sometimes there are various non-public schools that are offered to students who have the autism classification on their IEP. Excuse me. But what I do recommend is if you find yourself in a situation where you're in a dispute with the school district on either classification, evaluation, program, placement, you may want to take a look, you should take a look at the New York State Commissioner's Regulation on Special Education, sometimes referred to as Part 200 and 201. And that pretty much lays out all of the requirements for the impartial hearing, all the requirements for an IEP, who should be in a CSE meeting, who should be, when should evaluations take place, or what kind of program or placement should specific students be provided, things like that. That is kind of, your go-to place to see. And then additionally, there's also special education program manuals that you can easily access online. But I recommend, because although this can be done in impartial hearing, you can represent yourself in an impartial hearing, there are so many details, there's so many different things that you have to be mindful of that you may not even be aware that you have to do. It is best to try to consult with an attorney if possible, because even in something as we might find something simple, but for a parent it might be a daunting task to prepare disclosure. There are certain requirements, like a lot of impartial hearing officers require you to label the bottom of each page, each index number. You want to have Exhibit A-1. Even locating the documents, although under the FERPA laws, school districts have to provide students with disabilities and their families the educational record along with any IEPs, any other documents. Sometimes school districts do put up a fight on that. And sometimes it does take getting an attorney or an advocate involved just to be able to get documents. Something as simple as that, or sometimes coming to the table, it might be a daunting task. Parents might feel nervous. Additionally, you want to be mindful, if you're not comfortable with the language, you can ask when you're requesting for your impartial hearing, you want to make sure that you ask for a translator, and you let them know which language that you need the translator for. Maybe your witness needs a translator. So you want to be mindful of those things as well. Let me just see, we have another question. If a district is trying to remove a service, does the justification to decertify the service have to be made from formal reviews? Would an incident report for a fall be a document that could be requested from a school under FERPA? So documents under FERPA are anything that's contained in the student's educational file. So potentially, yes, that could actually fall under FERPA. It really depends on how they're labeling these documents. Additionally, if a school district is trying to remove a service, does the justification have to be from a formal? So not necessarily. Usually the best practice is, and if you're disputing this removal of a service, then you can bring the due process complaint to state that they didn't have a reasonable justification to remove the service. They didn't evaluate the student appropriately, and their removal was inappropriate. Even before going to the due process hearing or even filing, you can request that, I would like this evaluation. You removed his service. I want to see if he's making progress, if he's regressing, things like that. You as a parent can request evaluations from the school district. And as I mentioned before, the school district can either, grant your request and provide the evaluation, or they can say that, we're not giving it. Then you can get a private evaluation and present that to them to show that, let's say they removed physical therapy and it's now 2-3 months later, and then we see the evaluation shows that the student has regressed. So that's, one, showing the school district that they should probably put the service back in place. And two, if you are going to file an impartial hearing to try to get the physical therapy that the student missed out on for the last 2-3 months, then that would be your proof, that evaluation that you have. And additionally, I may have failed to mention that in an impartial hearing, you may also, obtain a independent evaluation that you paid for. You may try to get reimbursed for that as long as it's appropriate. And that would be something that you prove is that this evaluation is appropriate. You tried to work with the district to get one, and they didn't provide it. What about requesting a neuropsychological evaluation from the district? I'm not really sure what the question is, but yes, you can request a neuropsychological. There's various evaluations you can request from the school district. You can request an occupational therapy evaluation. You can request a physical therapy evaluation, a psychoeducational, a neuropsychological, which is a little bit more in depth in terms of reviewing the student's social emotional needs, their educational levels, various accommodations that may be assisting them, or other recommendations. Usually students with disabilities will be assessed to be a psychoeducational that a school psychologist from the district will do. But if you believe that it's not sufficient, or there's been a change in circumstances and that warrants like a more thorough evaluation, you can request a neuropsychological evaluation from the school district. And then again, we would be in that situation whether that's the school district's decision if they want to provide the authorization, if they're going to conduct their own neuropsychological, or if they're going to, deny your request. And at that point, that might be a reason for you to seek an impartial hearing. But it is well within the discretion of the hearing officer if you're in a hearing situation, and let's say the student has not been evaluated within the last 5 years. And under the statute, the student must receive what's called triennial evaluation. So once at least every 3 years, the student must be evaluated. So let's say that the student wasn't evaluated since like 2015, and now we're 5 years later. You're well within your right in your impartial hearing to request these independent evaluations. And so, as I was mentioning, the impartial hearing officer has broad discretion as to the relief requested. So sometimes when we have these various evaluations, like a neuropsychological that we have, and they're recommending things such as, maybe the neuropsychologist notes that the student is having difficulty with motor coordination. And at that point, nobody ever realized that the student needed occupational therapy or physical therapy, or even vision services. The specific neuropsychologist may recommend, we need an occupational therapy evaluation. So once this report gets to the impartial hearing officer, although you didn't request an occupational therapy evaluation in your due process complaint, the hearing officer may still grant and award an occupational therapy evaluation based on that report. So those are things to be mindful of as well. What if a student starts epilepsy meds after a psychoeducational and the functioning has changed? Should you be requesting reevaluation at that point? What if the district evaluations were recent? Well, so that's a change in circumstances, and that may warrant actually, a reevaluation. Let's say this very situation actually happened to one of the students that we assisted, and there was a change of circumstances, and we actually had, a very open conversation with the school district. At that point, they were like, they agreed, they saw that the student was very different from that time of evaluation to currently, due to her medications, due to this new diagnoses. If you have a school district that's not very open, that's not, that's giving you pushback, that may also be one of the reliefs. That may also be a reason for you to ask for a due process complaint, requesting these evaluations. And you can prove it to the hearing officer that circumstances have changed and these evaluations are now currently warranted based on this new, either new diagnoses or these new changed circumstances. So that's definitely something.
Mr. David Trevor is calling. He said you did a closing for him for 7018 73rd Street, and he's having some issue with it.
So if we don't have, I'm going to open the floor up to any more questions that there might be. But if you have any other questions, you can't think of them now, feel free to send us an email, feel free to give us a call. We're available to assist you, with any questions you may have with regard to impartial hearings, with regard to IEP meetings, with regard to disciplinary actions in special education. And with that, I also want to remind you of our next lunch with Littman Krooks, same time, same date, next week on Tuesday at 12 o'clock. It was my pleasure, and as I mentioned, if you have any questions, feel free to give us a call or email us. And have a great day. Stay safe, everyone.